What is the difference between reasonable suspicion and probable cause? By me, MacGavin. Answering the following three questions. A. What is the difference between reasonable suspicion and probable cause? How is reasonableness determined? Reasonable suspicion, as described in Haar and Hess, is an experienced officer's hunch or intuition based on observed conduct which leads him to believe that criminal activity is about to happen or has already occurred. The reasonable suspicion standard was established in Terry v. Ohio, 1968. The officer, McFadden, had reasonable grounds to believe the suspect was armed and dangerous. Detective McFadden, taking proactive measurements to protect self and others, reacted to this instinct based upon his learned experience and intuition. McFadden instinctively responded under the now-known reasonable suspicion standard and conducted a pat-down on the suspect known as John Terry. Terry was charged with carrying a concealed weapon illegally. Terry was convicted of carrying a concealed weapon and sentenced to 3 years in jail. Terry appealed the Ohio court's decision, and the case went to the Supreme Court, and in an 8-1 decision, the court held that the search undertaken by the officer was reasonable under the Fourth Amendment, and that the weapons seized could be introduced into evidence against Terry. Oyez.com, 1968. In considering the totality of the circumstances and chain of events leading to the arrest of Terry et al., the court's decision attempting to focus narrowly on the facts of this particular case, the court found that the officer acted on more than a hunch, quote-unquote, and that a reasonably prudent man would have been warranted in believing Terry was armed and thus presented a threat to the officer's safety while he was investigating his suspicious behavior. In contrast, but not too far removed from reasonable suspicion, is probable cause. Probable cause is stronger than reasonable suspicion, as the facts and circumstances within the officer's knowledge include the totality of circumstances that will lead a reasonable man to believe that a crime has been or is about to be committed. Perhaps a case to reference for the court standards for definitions and applications can be found in Ornelas v. United States, 517 U.S. 1996. As the court recognizes determinations of probable cause and reasonable suspicion involve a two-step process. First, a court must identify all of the relevant historical facts known to the officer at the time of the stop or search. And second, it must decide whether, under a standard of objective reasonableness, those facts would give rise to a reasonable suspicion justifying a stop or probable cause to search. Law.cornell.edu, 08. Examples that would lead to probable cause include the following, but this listing is not inclusive or comprehensive: flight, furtive movements, in-sight evidence, presence in or at a crime scene or a high crime area, criminal past or association with known criminals, personal observation, information from a CI, confidential informant, or reliable eyewitness. Gaines and Miller, 2006, include the probable cause framework in their description of what constitutes probable cause and how this benefits law enforcement. The concept of probable cause allows police officers to do their job more effectively. As most arrests are made without a warrant, probable cause allows the police quick reaction to the commission or commissions of crime or crimes, as they recognize a series of events that lead to subsequent arrest. You cannot expect a police officer to affect a warrant for every incident. The burden of probable cause rests on the arresting officer or officers' knowledge of facts and circumstances that would reasonably lead to the belief that an offense had been or is being committed. Brenninger v. United States, 338 U.S. 160, 1949. Gaines and Miller 06, page 164. Thus, the difference between the two can be seen in the demands that each requires. Reasonable suspicion requirements are less demanding compared to probable cause. In probable cause, the demands and standards are more stringent. For a judge to issue a search warrant, probable cause must show that it is likely that a crime took place and the person who is accused was involved in the criminal activity, and the officer or officers must affirm this to be true. Probable cause must be based on oath and affirmation, as stated in the Constitution, the Fourth Amendment. An affidavit is a written statement made by police or private citizens under the oath of affirmation that establishes probable cause beyond suspicion. If everything is in order, the judge edicts the warrant for search and or arrest. For B part, define and discuss the Fifth Amendment requirement of due process. And in your response, describe the process and purpose of the due process clause, which describes when it comes into play in a criminal action. According to Chemerinsky, 02, there are two processes under the due process procedures, and these should be differentiated as to meaning and implication. Chemerinsky divides them into procedural and substantive, and these distinctions should be understood. The Fifth and 14th Amendments, respectively, provide that neither the United States nor state government shall deprive any person of life, liberty, or property without due process of law. This clause has been interpreted as imposing two separate limits on government, usually called procedural due process and substantive due process. Procedural due process, as the phrase implies, refers to the procedures that the government must follow before it deprives a person of life, liberty, or property. Classic procedural due process issues concern what kind of notice and what form of hearing the government must provide when it takes a particular action. Substantive due process, as that phrase connotes, asks whether the government has an adequate reason for taking away a person's life, liberty, or property. In other words, substantive due process looks to whether there is a sufficient justification for the government's action. Chemerinsky 02, pages 523 and 424. Procedural due process refers to how laws are applied and what the government must do or inaugurate before it can deprive anyone of their constitutional rights, as described in the Fifth and 14th Amendment. The due process requirements apply to both civil and criminal arenas. Hare and Hess, 208, pages 270-71. From initial contact to incarceration, there is legal process or procedure that must be followed, and if the suspect is found guilty of any crime, their rights are ensured by a procedural chain of events that incorporates the due process clause or clauses, incorporated within the 4th, 5th, 6th, and 14th Amendment of or to the Constitution. Briefly, the procedure of due process starts with the commission of a crime. The crime is investigated by law enforcement, and a suspect or suspects emerge. Contact is made with that suspect, and if there is reasonable suspicion based on investigative information and exterior resources such as witnesses and confidential informants, the suspect is then interviewed but not interrogated at this time. if the questioning yields probable cause, and if they become a person of interest or a primary suspect, the investigation by law enforcement continues. When evidence is gathered and the evidence identifies the primary or person of interest being the probable perpetrator of the crime, law enforcement makes an arrest. While this arrest is being conducted, the suspect is advised of their rights under Miranda, and these rights include the following from the constitutional clauses in the 4th, 5th, 6th, and 14th Amendments, however not inclusive. You have a right to a lawyer. You have a right to confront witnesses. You have a right to testify or speak for self. You have the right to remain silent. You have the right to a speedy trial. You have the right to a jury trial. You have a presumption of innocence and must have probable cause for a warrant or arrest. The suspect is now in custody of law enforcement, and their liberty is removed, albeit temporary or permanent. If sufficient evidences exist, the suspect is charged with the crime and brought before a judge for a preliminary hearing or before a grand jury for presentation of evidence which produces an indictment or charges against the suspect. The suspect can then be released on bail if they meet the terms and conditions of the court. An arraignment is set. The charges against him are read, and the suspect now enters a plea of guilty or not guilty, and the suspect is then scheduled for a time and place of their next court appearance in the process. Also to be considered at this time in the process is whether the bail continues. In each step so far, starting with an arrest and then advising them of their due process under Miranda, the suspect is entitled to legal representation of their own choosing or by a court appointment. This attorney guides his or their client through each procedural process, making sure their rights are not violated at any stage of the due process afforded by law. The suspect now enters the plea bargaining stage of the due process and will be perhaps able to negotiate a lesser punishment for their criminal actions. If no plea arraignment is completed, the suspect must go to trial, or perhaps they pled not guilty to the offenses already and they want a trial by jury. The next stage in the process now requires an appearance before a judge and a jury for the case to be heard and then adjudicated. If the defendant is found guilty, he then faces sentencing for his crime or crimes. After the defendant is sentenced, another stage of the process takes effect, that being the appeals procedure or process. The defendant is then taken to a corrections holding facility pending the outcome of their appeal. Thank you for listening thus far, but let's go on with this next question. C. When does the Sixth Amendment right to counsel exist? How is that right different from the Fifth Amendment right to counsel? Although not specifically clause inclusive in the Fifth Amendment, the right to an attorney is granted by the Supreme Court legislative action in Miranda v. Arizona, 1966. This right is, however, contingent upon any suspect's current status with law enforcement. If any suspect is arrested by law enforcement for a crime, they are subsequently read their rights under Miranda. This now allows them, by the due process clause, procedure incorporated into Miranda by the Supreme Court by the coalescing of the Fifth and Sixth Amendments, the right to an attorney, these rights as understood by the ruling in Miranda v. Arizona, 1966. The Miranda warning. Miranda took the unique step of actually directing the police officers to tell individuals they had in custody before questioning them for specific warnings. The Miranda warning itself may be read from a printed card or recited from memory and must include the following. The Constitution requires that I inform you that you have the right to remain silent. Anything you say can and will be used against you in court. You have the right to talk to a lawyer now and have him present now or at any time during questioning. If you cannot afford a lawyer, one will be appointed for you without cost. R. & Hess, 28, page 275. Do you understand each of these rights I have explained to you? Having these rights in mind, do you wish to talk to us now? The right to counsel under the Fifth Amendment is not expressly written, but implied by Miranda. This is the difference between the Fifth and Sixth Amendment, wherein the actual Sixth Amendment wording says, and to have the assistance of counsel for his defense. This has now become a constitutional law by the Supreme Court's ruling in Miranda. The right to counsel is the only Sixth Amendment guarantee that extends beyond the trial. The Sixth Amendment provides an accused with an attorney not only during the trial but also at every critical stage of the criminal process. R. S. 08-2305. The Sixth Amendment right does not apply until the suspect is charged and becomes a defendant, and then this right extends beyond the trial to also include the appeals